It's now 13 years since the terrible events of those 6 days in August 2012, when 44 people lost their lives. It's important that we remember those tragic events. It's also important that we learn from them and from the events surrounding them. It's more than 15 years since the Marikana Commission produced its report. I'm not going to attempt to summarize the findings of the report. I would only note that the inquiry revealed a sickness in the South African Police Service, going right to the very top. Now, evidence has emerged of what looks like further very serious sickness in the SAPS. Justice Budlender, who was initially the senior evidence leader in the Marikana Commission, is now heading a commission of inquiry into the truth of the serious allegations and counter-allegations that are flying around, and into disputes and failings in the SAPS. The Marikana experience demonstrates how difficult it is to establish the full truth when people at the highest levels attempt to conceal it. We must all hope that he will be successful in his task. So I'm not going to talk about what the Marikana Commission found. Rather, I'm going to reflect on what I think are two important lessons which emerge from this history. The first lesson is about what the Marikana Commission did not investigate and what it could not tell us. The Commission was structured and functioned as a traditional, typical legal process. 44 people had died. So who was responsible for their deaths? Who was guilty and who was innocent? And who did what unlawfully? That was obviously very important, because that's what the public and those who had lost their loved ones wanted and needed to know. And there needed to be prosecutions of people who had committed crimes, and there needed to be dismissals of those who had failed to carry out their duties. We investigated this as fully as we could. But on reflection, I now think that we failed in a fundamental respect. We didn't look into the underlying causes of what happened. We had planned a second phase of the inquiry, which could have looked into this, but we ran out of time for it. And we ran out of time because we were busy trying to find out who was guilty and who was innocent. And so we were able to do only a very small part of phase 2. To me, the most shocking part of what I learned as an evidence leader and what we needed to investigate was not only the killings which took place, it was the level of alienation and anger on the part of the rock drill operators who were at the heart of the strike. They seemed to be so alienated and so angry that they felt entitled to do whatever it took to achieve what they wanted. One of the results of this was the brutal conduct which followed, some of it directed at their co-workers. The police response was to treat all of this as acts of war. 13 years later, I keep asking myself, what was it about the working and living conditions of the rock drill operators that led them to believe that they were effectively at war with their employer and with the law enforcement authorities? It's difficult for someone like me to imagine the conditions under which the rock drill operators work. Hour after hour, shift after shift, day after day, week after week, month after month, year after year, endlessly until you are exhausted and no longer able to work. It's difficult to imagine what it is like. We should have gone underground to get at least some sense of the conditions and the operations there. And we should have asked, what realistic prospect did the rock drill operators have of ever escaping from this life? Anecdotally, we heard that they had none. I don't know whether that is true. But these are people whose work is at the heart of the mining enterprise. They are the people without whom no mining can take place. And we should have asked how this relates to how work is valued and rewarded. We should have asked what, if anything, could be done about that. Perhaps this is all inevitable in the mining enterprise, I don't know. But whatever the answers, I suspect that they may go some way to explaining the anger, the alienation, and perhaps desperation that we saw. If this is indeed the case, these are questions that should concern all of us, and particularly all of those in the mining industry. If I were in the mining industry, what I would have taken away from Marikana was a deep concern that people who were working on the mines every day, living and working there for years, were in a state of undeclared hostility with their employer and with the law enforcement authorities. They considered themselves entitled to do anything at all, that would advance their interests, no matter the consequences for them and for others. That's a very serious and dangerous state of affairs. If you have people living on your property and working for you, to have those people in that state of mind should give you cause for reflection. We really heard nothing of this, not from the rock drill operators and not from those who ran the mine. We were all mainly doing what lawyers mainly do, trying to find out who was guilty and who was innocent. Speaking as an outsider, it seems to me that there are likely no shortcuts to finding solutions to these problems. It requires patience, open-mindedness, and a willingness to listen and to innovate. The second lesson I draw is related to this. The Bapu-Bamokhale community are the historic owners of the land on which platinum-bearing mines in the northwest near Rustenburg, including Marikana, are situated. The community had a right to royalties in respect of the minerals extracted from the land. But Lonmin had a problem. The 2004 mining charter required it to have 26% black ownership, and so Lonmin proposed that those royalties be converted to shares in order to enable it to reach its target of 26%. There were negotiations between Lonmin and people who purportedly represented the Bapu-Bamokhale. An agreement was reached, which enabled Lonmin to reach the 26% black ownership level. But there were large numbers of people in that community who were effectively excluded from the process and who were deeply dissatisfied by it and its outcomes. Lonmin's attitude seemed to be that they would reach an agreement with the statutory traditional council. They bent their backs to achieving that. But in fact, there were real disputes about who really represented the community and whether the traditional council represented all who had an interest. The authors Gavin Capps and Stanley Malindi, in a detailed article based in part on Malindi's research for his master's thesis, refer to, quote, the diverse settlements that make up the 40,000-strong Bapo community, close quote. One should not be surprised that there are different views and different representative bodies within a community of that size and that nature. Lonmin's attitude was that it had to deal only with the traditional council. Finally, on 20 July 2014, a portion of the community attended a meeting organized by the traditional council. 779 of those present voted in favor of the proposal, and 51 voted against it. The meeting passed a resolution authorizing the traditional council to conclude the deal with Lonmin. The next morning, Lonmin signed the deal with the Rangwane and 2 other community representatives. The full details of the deal were never made public. But we will never know how large a part of the community knew about the deal and supported it. There were a lot of questions about the legal validity of the council and its power to conclude an agreement of the sort, but I'm not concerned here with questions of legality. To focus solely on legality is to miss the point. This was not an ordinary commercial deal. It was about the right to land held by a community for generations and from the benefits that accrue from the land. It seems to me that the exclusive focus on supposed legality was a fundamentally flawed way of dealing with the matter. In this situation, it's necessary to open the dispute up, to expose all of the contested claims and to address them. If you supposedly resolve a dispute such as this through a closed and limited process, you invite trouble in the future. And so I hope that the present owners of the mine are aware of the limitations of the deeply contested process that was undertaken by Lonmin. I don't make a judgment about the rights and wrongs of the traditional council and the deal that was made. What I point out is that there was dispute, and that as a result of how the matter was dealt with, it would be surprising if the dissatisfactions and disputes do not continue. This, of course, does not only apply to Marikana. I think a far-sighted mining company would say, I'd better engage with everybody. It doesn't help to engage only with the officially recognized traditional leaders, because that may leave many people dissatisfied. As it happens, the legal landscape has changed fundamentally since that deal was done. When I was a young lawyer, a highly skilled property lawyer explained to me, South Africa is a mining economy. Property law is structured to recognize and facilitate this. Mining rights therefore trump all other rights. For many years, we all proceeded on this basis. Then 3 things happened. First, in 1996, the Interim Protection of Informal Land Rights Act was passed. It was called IPILRA. IPILRA protects people's land rights under customary law. They can't be deprived of those rights except in accordance with the procedures set out in IPILRA. Second, in 2006, the Mineral and Petroleum Resources Development Act was passed, the MPRDA. Section 5 of the MPRDA says that the holder of a mining right can go onto the land to which the right relates and mine it. That seemed to confirm what had always been the case. Mining rights trump other rights. Then third, in 2019, the Constitutional Court handed down judgment in the Maledu case. The court noted that IPILRA provides that no person may be deprived of an informal right to land without his or her consent. Where land is held on a communal basis, a person may be deprived of the land or a right in accordance with the custom or usage of the community. All affected persons must be given notice, and all must be given a reasonable opportunity to participate at any community meeting where a decision to dispose of their rights is to be taken. Such a decision requires the support of the majority of the affected persons who are present at the meeting. The court held that the MPRDA doesn't abolish those rights. That has changed things fundamentally. Now, where land is held communally, all of the people living on it and using it have a right to at least part of that land. So they all have to be consulted before any decision is made by them or made by someone they've authorized to dispose of their rights. If the holder of a mining right wants to mine the land, it must go through a dispute resolution process with them as set out in the MPRDA. And so the mining industry is faced with a new situation, where it wants to mine communal land over which it has a mining right. It must enter into a consultation process with the members of the customary community, not a traditional council, and obtain their consent. When all else fails, it can ask the minister to expropriate the land or the rights in the land. This requires mining companies to respect rural people's land rights and to deal with the people properly and respectfully. It requires what should always have been the case, a recognition that all of the people living on the land have rights to it, and that those rights and those people must be treated respectfully. Mining companies can no longer say, as they did in the Maledu case, that the granting of a mining right expropriates the rights of the people who are living on communal land. Those rights continue, and their rights have to be respected. And so it will be necessary to obtain the consent of the members of those communities to mining on their land by dealing with them directly or through their properly authorized representatives. Quick fix deals with traditional councils, the method always used in the past, will not be a solution. So it's now 13 years after Marikana. We have to reflect on the lessons of Marikana. One of them, of course, is to ensure that the police act like police in a democratic state, dealing with people as citizens, not like an army dealing with an enemy force. But I suggest that there's also a need to address the underlying issues, and I've addressed 2. First, what is it like for people to spend their working lives underground drilling rocks with no prospect of change or advancement? And what are the consequences of that situation? And second, the need to recognize that people who occupy or use land, including communal land, have rights that are protected under the Constitution. These are not easy matters, But in my opinion, it's only if we address these matters that our mining industry will be able to thrive, to the lasting benefit of those who work on the mines, those who own the mines, and our country.